Happy Friday, thank you. But look at this for a minute. Tell me what you think about it. I want to know what you think. Yeah, but that's what I don't understand. Like what motions? Because usually that's if they ask. I guess they could have done a. They could have already had a hearing on a release. I didn't see that in the documents though, so I'm gonna hold on. Let's see here. History. Is it which page is it sharing? Are you guys just seeing the custody one? This is about Brian Koberger, the accused killer for the 4 University of Idaho students. And okay, so let's stop sharing that one. And we're going to share this one. I guess I'm just going to share the whole screen. Screw it. It doesn't on here though. Yeah, let's just do entire screen and share. Okay, I don't know how that's gonna look when you. So you guys see the judicial cases of interest tab, right? Is that what you guys see? Okay, yeah, that is what you guys see. Okay, okay, see this? This has to do with all basically what the court has filed so far in this case. Now, this is the custody order of the sheriff. Oh, let's see what that is. I think I've. So this is when they. Okay. So this is when he got. I think this is when he got extradited from Washington or Pennsylvania. Yeah, Washington to here. And the reason why he went to Washington first is because the warrant for his arrest came out of Washington because he was a resident of Washington. So he was extradited there and then extradited to Idaho. Now this one just says this is the 5th it said. And so only the one is marked, right? You see the defendant shall the following terms. And then I don't know why it doesn't say that he reported to jail. But it says email to the jail. Okay, but there's no bail. So then we have It's what, Bubba? So that's the custody order. Oh, what happened? Come here. So this, oops. This has to do with when his court date is. And come here, Baba. Oh, I love you so much, honey. You're so funny. Hey. I'll be chewing on that. Here we go. No, thank you. Thank you so much for your help, Bubba. That was sweet of you. Here you go, right here. This way. That was so sweet of you, buddy. Thank you. I love that you're helping, Mama. Here you go. Here you go. Here you go, Bubba. Here. You want this or not? Look. Here. Look. Yep, right for you. Court noted the presence of the counsel and the other. Oh, this is what I want to show you guys too. Oh, what the heck? Why is it doing that? No way. Oh, I was going to say no way. They request a preliminary hearing be scheduled in accordance with the time limit set forth in Idaho. I thought they already had the preliminary hearing, and that would have been the 12th, for his first court appearance. That should have been the preliminary. But I guess some states, they have a different order of courts hearings. Now, right here, this is probably why they did do the custody one, because he's asking for a bail reduction because he's at no bail, and they call it a bail reduction hearing because usually people have a bail and they want it lowered, and that's the name of the hearing. So he is trying to get released. He's totally trying to get released. Now I need to find out what the criminal rule 46 is. Let's see here. Counsel intends to present evidence and argument in support of all applicable factors outlined in Idaho Criminal Rule 46. Where is it at, buddy? Where's it at? Here. Oh, there you go. Whoa. My happy boy. Okay, the Idaho Rule 46 is a formal exception to a ruling or order is unnecessary. So this is objecting to a ruling or order. When a ruling or order is requested or made, a party need only state the action that it wants the court to take or objects to, along with the grounds for the request or objection. A defendant who is charged with a crime that is not punishable by death must be admitted to bail or released on the defendant's own recognizance at any time before a guilty plea or verdict of guilt. In the discretion of the court, bail or release on the defendant's own recognizance may be allowed in the following cases: after the defendant pleads guilty or is found guilty and before sentencing, while an appeal is pending from a judgment of conviction, an order withholding judgment, or an order imposing sentence, except that a court must not allow bail when the defendant has been sentenced to death or life imprisonment. Okay. On a charge of a violation of the terms or probation, or on a finding of a violation of the conditions of release subject to the provisions of Idaho Code. Bail where offense is punishable by death. A person arrested for an offense punishable by death may be admitted to bail by any magistrate or district court authorized by law to set bail in accordance with the standards set forth in Article 1, Section 6 of the Idaho Constitution. Factors to be considered. We'll have to look at that in a second. The determination of whether a defendant should be released on the defendant's own recognizance or admitted to bail, and the determination of the amount and conditions of bail, if any, may be made after considering any of the following factors: defendant's employment status and history and financial condition, the nature and extent of defendant's family relationships, defendant's past and present residences, defendant's character and reputation, the person who agrees to assist the defendant in attending court at the proper time, the nature of the current charge, and any mitigating or aggravating factors that may bear on the likelihood of conviction and the possible penalty. Defendant's prior criminal record, if any, and if defendant has previously been released pending a trial or hearing, whether defendant appeared as required. Oh, you're fine. Okay, right to bail. Okay, pending appeal. Defendant may be admitted to bail or released on the defendant's own recognizance by the court in which the defendant was convicted, pending an appeal on consideration of the factors set forth in subsection C of this rule, unless it appears that the appeal is frivolous or taken for delay. And they did issue no contacts to five no contact documents were filed. So he is requesting that. Okay, so I wanted to look up, what is it? Article 1, Section C. Section 1, Article C. What the? How is? Oh, haha. Son of a... My bad. There we go. Section 6. My bad. I totally did that wrong. Cruel and unusual punishments prohibited. All persons shall be bailable by sufficient sureties, except for capital offenses where the proof is evident or the presumption great. Excessive bail shall not be required, nor excess fines imposed, nor cruel and unusual punishments inflicted. Damn, that's gonna be a tough one to fight. I mean, that's gonna be a tough one for prosecution, because at that point it's gonna be up to the judge, because it looks like what they're going to do is probably have the argument that he hasn't been found guilty of capital murder or murder, and capital murder is where it's punishable by death. He's being charged with murder in the first degree. So they could argue that it's basically not been proven yet that he's guilty of murder, so at that point it would mean that technically he should have a bail. I don't that's gonna be a tough one. That's gonna be interesting to see. No, I haven't watched. Sorry, I was not looking at that yet. No, I have not. No, this is an Idaho court though that filed the frickin' custody of sheriff's office, whatever. Where's Q? I don't see Q. Oh, what? Where's Q? What is he doing? Is he messing with my shit right now? I don't know. I find it interesting, and it really seems weird, because like this was filed on the 12th, and he's not being transferred to any other jail that I know of so far. And now what am I doing? I don't even know how to get rid of this now. Holy crap. Oh, there we go. Stop screen. Yeah. I don't know. I find that very interesting. So I guess we'll wait to see. But so then, I mean, obviously there's a site that shows all the documents that. And have you guys seen the search warrant? I mean, the search warrant of his apartment. I'm sure you guys have heard stuff here and there, but people keep like adding on, and I hate that shit. Like word for like, I hate how they like. I don't know. Hold on, 1 second. What? What about it? Where? No. You're funny. We're gonna grab it. You. I love you. I love you. Come here. How they exaggerate. Like they found hairs, animal hairs, yes, at the apartment, and they took spots like off of a pillowcase. There was like a couple items that they took that said a brown, like reddish material, or a brown reddish, color. But it says clearly next to in parentheses that it said collected but not tested. So I mean, it could be ketchup. It could be like honey barbecue sauce. I mean, it could be anything. And yeah, I mean, and he's they're gonna have. This is gonna be a very interesting trial. A very interesting trial. And let's see. I'll share this one real quick. Yeah, let's do that one. Yum. Okay, so when you guys wear that. I'm sorry, grunge truck. What was the interview room about? Oh wait, interview room. Yeah, that's that girl, right? I like her. I like that girl. I like her because she seems to be one of the few that. What are you doing, Bubba? Creepy, you creepy kid, you creepy kid. She seems to be like one of the few that sticks to facts. Here, where's your train? Come get it. Nope, it's right here. Yeah. Yeah. So there's that. I'm gonna pull up the one more thing that I found interesting. Oh, did you guys know the reason why the crime scene was being held preserved until the beginning of February is because of Brian himself and his attorney. And I know that there's more than we know as far as Dylan's witness, testimony. It's just not adding up. I think that if she opened the door and saw the killer leaving and she was frozen in fear, there's no way, like, unless someone's theory is correct about him hearing the dog barking or freaking out and that spooked him enough to just get out of there. But there's no way he would have left her alive because that would be a witness no matter what. I think that if she did see the killer, well, no, she did say bushy eyebrows. So no, because I was thinking, really, kid? I was thinking maybe like she saw him like leaving and saw his back like leaving, but she said bushy eyebrows. Can I help you? Hi. Mm-hmm. Yeah. Oh, welcome to having kids, people. Hi. Why do I think he might be getting released? Because this right here was filed on the 12th, okay? And this was saying stipulations for, upon release. And then, oh wait, I guess I'm not sharing the page. Hold on. I forgot. Oh shit. God, hopefully tell me if there's going to be a loud noise or not. You bitch. Okay, this right here is talking about this is basically says the above named defendant appeared in the magistrate's division of the district court this date, and the sheriff of Latah County is hereby notified of the following custody status. Now, it just says the defendant shall comply with the following terms, states the court date, says don't drive. These are the ones that aren't checked, about not driving, not violate any terms of probation, and see pretrial release order. The ones that are checked is, must appear for all court hearings, not violate any laws, not consume or possess any alcohol or enter any bars or liquor stores, not consume or possess any controlled substances unless lawfully prescribed to the defendant, stay in contact with attorneys, sign a waiver of extradition before being released from custody, not possess any firearms or weapons, have no contact with the alleged victims. Now, here, look at this. Shit. Yeah, but why? So there's that one. Hold on, let me pull up one more thing. I'm just going to share the whole screen. They already filed one on the 5th when he was being extradited from Washington to Idaho. So that makes sense. So either he's being released or he's being transported to another facility. Because, I mean, but it says the court dates, it says that they're going to be with the same judge, Megan something, on June 25th or 26th. I'll look at that again. But it's going to be the same judge. So he's not going to another facility, as far as I know. Let me share the screen. Okay, so the case summary, right? So we just read that about the stipulations upon release. And then, so, no, okay. Affidavit A statement, affidavit redacted. Redacted and redacted. The probable cause order and the criminal complaint are released now. Okay, so here's the... Okay, so right here is the... He had his initial appearance on the felony magistrate court. And then notification of rights, application for a public defender, and then no contact orders were all issued for the 5th. And that's because of they have to do that upon the release because he was being released from Washington to be extradited to, oh, no way, you guys. I wonder if he's being charged for a crime back in Pennsylvania, and it would make sense that he had to... Because, okay, so say it like this. So in order to be released from Washington, just like if he was being released normally, like if he was being released either on his recognizance or on bail or no bail, they would have to do the same paperwork for him to be transported to the other facility, which would have been Idaho. And so this right here on the 5th is the no contact orders that were put in place and the custody order of the sheriff, which this is the sheriff of Idaho. But this basically was the stipulations for being released to the Idaho facility. Now, if you think about, and all those are all the no contact orders put in place for, all the alleged victims for this crime. So what if he's being charged with a crime back in Pennsylvania? Because look. Oh, no, wait. Yeah, those are victims' rights. Oh, that's a new thing. I didn't see that. See, it's another custody order of the sheriff. So that's what I don't understand. Why would there be another one filed for the 12th if it was already filed for the 5th? So, yeah, maybe he is trying to be released again or released on his own recognizance or for a bail amount. But that would be crazy if he was maybe going to be released to another facility being charged with a different crime. I don't know. That's weird. Oh, you guys can even see it the whole fucking time. Oh, that pisses me off now. Ugh. There is another bond hearing. That was the 12th. The bond hearing was the 12th. And they're requesting another one, which is this paperwork right here. This one right here. Now I can't remember which one it is. This one right here says, Ann Taylor. Okay, comes now, which is the person present, Ann Taylor, public defender, and pursuant to court appointed, hereby appears for and on behalf of Brian C. Kohlberger, the above-named defendant in the above-entitled matter, and requests that a preliminary hearing be scheduled in accordance with the time limits set forth in Idaho Criminal Rule 5.1. Now, the reason why it's June, they did want it sooner, but it wasn't going to work for the courts because they are asking, the attorney and Brian are asking for 5 days for the preliminary hearings, because they have a lot to bring up, I guess. And there was the closest date that would work with the courts and with Brian's attorney and whatnot was for June. And so they already handled all that. That's why it's June. It says, counsel hereby moves for reduction of the bail set in this matter on the grounds that it is excessive, and further notice is hereby given that counsel will present argument in support of the motion to reduce bond at the time of the preliminary hearing status conference and or preliminary hearing scheduled in this matter if the defendant is in custody. See what I'm saying? So they're trying to get him released. Counsel intends to present evidence and or argument in support of all applicable factors outlined in Idaho Criminal Rule 46, and that was the criminal rule that we just read at first before we went to the Idaho Constitution. Counsel further notifies counsel in the court that such request will be heard at the preliminary hearing status conference unless the case proceeds to hearing. If the case proceeds to hearing, bond shall be addressed at the time of the preliminary hearing. Counsel hereby moves the court for an order shortening time for bond to be addressed if timing is insufficient. The defendant hereby demands a speedy jury trial as guaranteed to him by the 6th and 14th Amendments to the United States Constitution, Article 1, Section 7, 13, and 18 of the Idaho Constitution. Notice is further given that the defendant herewith asserts all rights accorded him or her under the 5th, 6th, and 14th Amendments to the Constitution of the United States and under Article 1, Section 13 of the Constitution of the State of Idaho and all prophylactic, that's an interesting word to use there, measures imposed upon the state pursuant to said constitutional provisions, including but not necessarily limited to the right to remain silent and the right to counsel. This is where they put, this was the request for the gag order basically to be, I would say more strict. No agent of the state or person acting in such capacity is to question the defendant in regards to any act, whether charged or uncharged. So that basically includes like guards, prison guards, you know, the correctional officers, what I'm trying to think. Sorry. Like anybody that could have anything to do with state, like, yeah, nobody. Attorneys, paralegals, you know, assistants, cops' wives, cops, you know, attorneys' spouses, children, all of it. Yeah. I know he's not going to get bail. I know they're not going to lower the bail, but they do bring up a good argument according to that I just read the article. Article 1, Section 6. Yeah, actually now I'm going for, I finished my associates. Now I'm starting the bachelor's. Starting my bachelor's. Like literally on the 21st of February. It's my first day. Okay. Wow. Yo, that was redacted. Okay. I don't remember seeing that one. That one's different. Okay. In a week or two to make the final determination, Mr. Thompson stated there was no objection. Court set this case for status on January 12th. I believe that is when they had the hearing. Yeah, Baba. Okay, yeah, see, without bail pending further order of the court. Two years. Wow. Okay, so that was basically the transcript or the timeline of what happened on the appearance on the 5th. Let's see here. Okay, so they did want July. The state wanted July, but June works. Court advised the defendant of the rights he is waiving upon waiving his right to have a speedy preliminary hearing. Defendant understood. In response to inquiry from the court, the defendant stated that he did not need any additional time to speak with Ms. Taylor regarding his waiver. Defendant waived his right to have a speedy preliminary hearing. Ms. Taylor agreed with the waiver. Court found the defendant's waiver of speedy preliminary hearing was knowingly, intelligently, and voluntarily given in open court with the assistance of counsel. Court accepted the defendant's waiver. Court set this case for preliminary hearing on June 26th, 2023 at 9 a.m. and will reserve the entire week. Hi, Baba. Oh, you do have my phone. Thank you. Okay, here you go. No, you can't. You cannot throw my phone down. I will let you hold it. I will let you hold it, but it doesn't have its case on right now, okay? Here. Court remanded the defendant to custody of the Latah County Sheriff without bail. So they will still be addressing the bail. Will you grab your train, buddy? Grab your train. Grab your train. You can't have those. They'll spell mommy and daddy's in your name. Look at all the other letters you have. What about the ones you threw out in the living room? Look at them. What do you want? Oh, all right. I'm getting off here. I just wanted to talk about that and show that paper, but I'm gonna go lay little man down. It's time to go. It's time to go to bed. It's time to go to bed. Oh, you're getting heavy, boy. Hi. Say hi. 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 Oh, my sweet boys. You say hi, Bubby. My happy puppy is. Yeah, I don't think it is either. I love you. So, my sweet boys, yes, you are.
Nicole.
What?
Nicole.
Your nose is getting okay. All right, yeah, I'll go live later though, just to chill. But yeah, you want the light? Okay, here. Here we go. No, not that. Yep. No. Other one. Yep. That one. Do it again. Good job. I love you. Pull down. Down. Harder. Pull down. No. Yep. Good job. One more time. Do it. Hurry. I don't want it dark in here right now. I love you. Okay. All right. Bye.
I didn't do it yet.
What?
I didn't do it yet.
Where? Go grab your train. Grab your train.
Yeah.
Okay, it's the lights. That's right. It is the lights. Come on, let's go. Let's go. Come on. No, don't touch those. Yeah, sorry, but we didn't do that. Where's your train? Oh, there's your train. He's stuck.